Thank you. It's really great to be here, and I really want to thank you, Don, and also Joanna for the incredible work you've all done getting this organized. And it's a great opportunity for me, and hopefully an opportunity for those who are interested in the relationship between social choice and the law to move forward and make this a firmer research agenda than it has historically been. So I initially sent Don a paper, and that paper was posted. But when he told me I had a full hour to speak, I thought it might be better to put that in some context. And so what I'm going to do is talk about half the time about what I've been doing, and then the other half talk about that paper. And you'll see how this all relates. And I changed the title from the title of the paper, which is Scrutinizing Tears, although I will present Scrutinizing Tears, to a gentle madness. And now let me tell you why I called it that. So I grew up in a somewhat unusual home. My father was an avid book collector, collector of memorabilia, collector of ancient artifacts, collector of ephemera. It was a bit like growing up in the first floor of a Smithsonian museum, except in the confines of a rather small ranch or modest home, one floor that I lived in my neighborhood. And one of the curiosities is that my father, who passed away this year, who really was an autodidact in the truest sense, I mean, he really educated himself about history and collecting. It was always anathema to him. He just could never understand why I didn't understand his collection. He would keep bringing things in, and he would have all these intricate connections across these different collections that he had. I think he counted 30 different collections that he had. He could never understand that I couldn't fully embrace it and appreciate it. And I found this book called A Gentle Madness, the full title, A Gentle Madness, Bibliophiles, Bibliomanes, and the Eternal Passion for Books, which describes people like my father. And there's a quote in the book by a fairly well-known, I guess, Philadelphia bookseller, and it's this. It says, "It's paradoxical but true that not a single great library in the world has been formed by a great scholar." Now, again, I don't want to fancy myself as a great scholar, so let me dispel that notion, but let me just say that this might not be true. It might not be true, but whether it's true or not, it should be true in the same way that, although the story about Eskimos having 52 words for snow isn't true, linguists stick with it anyways because from their perspective it should be true. Well, this one should be true. This one should be true for the simple reason that it's really intuitive. And the intuition goes like this. Those of us who do fancy ourselves scholars, great or not, are about the pursuit of ideas. And so we are wedded to the notion that we're in search of something, and the books or the articles or whatever it is that contains it is a means to an end, and once we have it, we're done with it, push it aside, next project. The filing system isn't so important. And so as a result, it's easy for me to understand what my father couldn't, but, and this is where it connects to social choice, it doesn't mean that gentle madness goes away. It just manifests itself differently. And that's the fundamental lesson of social choice. You can't make cycling problems go away. They'll just manifest themselves differently. So my gentle madness has just been different from my dad's. And my not quite singular obsession has been using tools of positive political theory with a heavy emphasis on social choice to explain things that people tell me make no sense. That's what I do for a living. And because I actually teach constitutional law and focus on the Supreme Court, the particular areas in which I tend to hear those claims and do the exploration have to do with constitutional doctrine, public law, and constitutional decision making. So what I'm going to do now is go over what I think I can say is my 22-year ongoing research project. I was talking before we formally began this program with Bruce and Leo and Don, and I made the observation that, you know, I was thinking of saying, and now they've validated that I can get away with saying this, that I think that I have spent more time thinking about the relationship between social choice and the law than just about anybody with the possible exception of Bruce. I think I can make that assertion. And so I'll spend some time talking about what I've been doing for the last couple of decades, and then I'll tie it to this particular article that was circulated on Tiers of Scrutiny. So when I began teaching, I came across a number of scholarly articles that had discovered that Arrow wrote this thing called Arrow's theorem, and Condorcet had discovered this thing, or Border discovered this thing called cycling. And they said, well, you know, that explains why what Congress does is dysfunctional. And the dysfunctions in Congress normatively justify a sort of seismic shift in decisional responsibility from the legislatures to the courts. And the timing of these claims was actually pretty good for me because I was just starting to teach constitutional law. And I discovered that, in fact, it turns out that I could observe certain kinds of social choice dynamics embedded within particular Supreme Court cases. And so these normative claims struck me as potentially problematic. But more problematic was the methodological approach. The problem was that you find a defect in one institution, and then you say, okay, let's change what that institution does and have another institution do that, without systematically thinking about how one makes the judgment as to which institution gets a particular assignment. And it occurred to me that Arrow's theorem provided a kind of vehicle for trying to do that in a more scientific way. And so it's clear that Arrow wasn't trying to come up with a perfect institution. Quite the contrary. He was trying to come up with an institution that satisfied a set of fairly minimal conditions, which in the Vic-Ray simplification, it's rationality or transitivity, range, independence, unanimity, non-dictatorship, but prove that no institution simultaneously can satisfy all of those conditions. And what I sought to do is to say, look, we can set that up as a frame of reference against which to engage in comparative institutional analysis. Instead of just comparing Congress to the Supreme Court, we can compare each institution to that framework, because Arrow's theorem means that there's going to be a relaxation of at least one of these conditions in each institution. And it might be that the relaxed conditions are different. And then once we know what the differences are, which I call the Arrovian profiles, we have an Arrovian profile for Congress and an Arrovian profile for the Supreme Court, then we can ask the question, given these profiles, which assignment makes more sense, the one we have or the one you've proposed? And so that's the methodological approach that I've spent a lot of my time working on. And it turns out that the Arrovian profiles for the Supreme Court and Congress are opposite in a critical sense. The Supreme Court relaxes range, but largely adheres to independence, and it's the flip for Congress. Congress clearly relaxes independence, but largely adheres to range. These are the Arrow's conditions. This is an audience that I don't think needs me to go through them. Of course, I'm happy to if you'd like me to. And I don't think I need to spend a lot of time on this, but I'll spend a moment on it. The range condition requires that your decision makers be allowed to rank any of three options in any order of their choosing. And I go through this exercise with my students. I say, how many ways are there to rank options A, B, and C? And there's a smart way to do this and a not so smart way to do this. And I'd be delighted if one of my students latches onto the smart way. This is as mathematical as I get, Don. And I hope that a student says, oh, 3 factorial, 3 times 2 times 1 is 6. And of course, that's the answer. And then I spell it out. There are the 6. The problem with range is that if you allow your decision makers to choose from any of those 6 possible orderings over the 3 options, then it's possible, this is the 6 possible orderings, it's possible to yield a combination of preferences that cycles. If you choose A, B, C, one person, second person B, C, A, third person C, A, B, when you put it together, you'll have a cycle, and as a consequence, you'll run the risk of violating the rationality or transitivity condition. And so the question is how it is that the Supreme Court ends up relaxing range or Congress ends up honoring range. And the critical point here is that if the court honored range, then in those cases in which its preferences cycled, there would be a risk of not being able to resolve the case. So this is one of the very first cases that I happened to come across that brought this issue to the head for me. This is a case that is probably, it's not a famous case, but it's a famous case for those of us who teach constitutional law, but it's not like Brown v. Board of Education or something like that. It's a dormant commerce clause case. It has to do with a state law in Iowa that prevents 65-foot twin trailers from going through the state. The problem was that the surrounding states allowed these rigs. And what that meant was that for the trucking companies that wanted to take these rigs across Iowa, they had a choice either to go around a big state or take one trailer, go through, come back at the other trailer and go through. It is extraordinarily burdensome to Congress. And what happened in this case was that there was no majority opinion. Instead, there were three separate opinions, one for a plurality, one for a concurrence in the judgment, and there was a dissent. Now, in Supreme Court and constitutional law speak, a plurality has a specific definition. A plurality opinion is the opinion consistent with the outcome that gets the most votes. What's curious about that is the plurality opinion might not be the opinion that gets the most votes. The dissent might have 4 votes, and you might have a plurality of 3 and a concurrence of 2. But the plurality is defined as the opinion consistent with the outcome that gets the most votes, just by way of language. What happens is, if you read all 3 of these opinions, you discover a startling fact. All 3 of them agree on something. And what they agree on is, if you apply a relatively relaxed evidentiary rule, you allow the lawyers to come up with new arguments as to why this law makes sense and why it's not just protectionist. And if you apply a relatively relaxed substantive standard, the rational basis test, meaning can you state a justification without laughing out loud, then the consequence is to sustain the law. Here's the startling proposition. In the absence of either of those, the result is to strike the law. And what we end up with is Justice Powell essentially applying a stricter test and therefore striking the law, Justice Brennan applying a stricter evidentiary rule and therefore striking the law. They carry with them 6 out of 9 justices. Justice Rehnquist applies the laxer of the 2 rules, thereby voting to sustain the law. And on an issue-by-issue basis, he would win. On an issue-by-issue basis, the dissent would have prevailed, but because the Supreme Court uses an outcome voting rule, where you vote on the outcome and then you figure out how you got there in your opinion, you have the result of striking it down. So this actually led to a literature, not this particular case. There were some other cases that have the same feature to it, although it's uncommon, led to a literature in which a number of scholars advocated that what the Supreme Court should do is change its voting protocols from outcome to issue-based voting. And there's a number of articles out there. I've debated in the literature with several of these folks. And it turns out that social choice helps to explain why that doesn't work. There are 3 reasons that the issue voting rule would actually prove to be more problematic than the rule that we have. The first one is that the outcome voting rule, which is a non-Condorcet rule, it's a range-relaxing rule. It breaks the cycle. What it does is it guarantees you an outcome even when preferences cycle, but it's coupled with a second rule, which I'll get to in a moment, called the narrowest grounds rule. So when you actually have a case in which the opinions are more neatly aligned, and there's a Condorcet winner, even if there's no majority, you will actually get that under the outcome voting in the narrowest grounds rule. I'll come to that in a moment with an example of that. The other reason why the issue voting rule proves to be problematic is that what you're doing is coming up with a proposed rule to deal with a relatively exceptional set of circumstances. But if you have an issue voting rule across the board, this may not be as exceptional as you previously thought. It might be the case that the justices on the court will seek to articulate issues to create a favorable decisional path, whereas the outcome voting rule disciplines them to try to come up with the most persuasive account to get the most votes. So the other example of a case without a majority is this one. This is Memoirs of a Woman of Pleasure versus Massachusetts. This was the opinion that was at issue in the obscenity prosecution called Marks versus United States that led to the articulation of the narrowest grounds rule. What the court said in that case is the following. If you have a non-majority opinion, so you've got the Supreme Court deciding a case, but no single opinion captures a majority of the court. The way you know what the holding is as follows. The opinion that is consistent with the outcome that resolves the case on the narrowest grounds. The opinion consistent with the outcome that resolves the case on the narrowest grounds. Now, what that really means is very simple. This double line separates the dissent from the opinions consistent with the outcome. We can line them up on a single dimension from very broad protection of obscenity to relatively narrow exception of obscenity. This so narrow that they actually would deny relief, these sufficiently broad that they would grant relief. If you then ask yourself which one is decided on the narrowest grounds, it's the standard that's closest to the dissent. Although they strike down this conviction, they leave open more possibility for successful prosecutions than those that articulate a broader rule. But the easier way to think of this is social choice. Take the A-B camps and think of them as A/B and ask, what are your ordinal rankings? A, B, C, D. Ask D, what are your ordinal rankings? D, C, A, B. We don't really care about C's ordinal rankings. Whatever it is, C is the Condorcet winner. The narrowest grounds rule is a Condorcet rule, so now we have the two-part scheme. We have a cycle-breaking rule called outcome voting, one that minimizes opportunities for strategic behavior. Then we couple that with a rule called the narrowest grounds rule, which says if it turns out that the non-majority opinion has a Condorcet winner, that's going to be the opinion that expresses the court's holding. And that is a fairly successful regime based on the numbers. Now, one of the arguments that I got pushback on that relates to something Linda was talking about was, I say, and I just said, that the Supreme Court has to decide cases, as a consequence of which it has to relax range. But folks said, well, you know, Stearns, you might have heard of this thing called standing. After all, you teach constitutional law, or you at least purport to. And so I said, yeah, let me double down on my theory. I'm going to dig in. I'm going to see, because I actually believe that standing is not the crazy doctrine that you all think it is. Standing actually might make sense. Otherwise, it probably wouldn't have persisted for quite so long. It turns out, in fact, that although it's among the most contentious Supreme Court cases, it's not a heavy lift for a social choice person to figure out what's going on. So here's the way to think of it. We know that outcome voting is a cycle-breaking rule. Don just talked about Robert's Rules of Orders, and Robert's Rules of Orders mechanisms for breaking cycles, one of which is a rule that says no reconsideration of a defeated motion, standard cycle-breaking, path-dependence-inducing rule. Well, the Supreme Court happens to have one of those, as does every common law system. It's called stare decisis. Stare decisis says that in two case sequences in which the second case is indistinguishable from the first, the judges in the second case don't ask the question, what would we do in an ideal world? What they do ask is, does case one govern the case that we're deciding? It is a range-restricting, cycle-breaking rule. So that's what I've just demonstrated, that you ask in case two, does case one govern? And so what happens is, the common law process, which also characterizes constitutional doctrine, induces path dependence because the order of cases affects doctrinal development. We can live with path dependence. That's just arbitrariness. We may not like where it goes, but so long as it's arbitrary and no one's manipulating it, that's okay. The problem isn't the path dependence. The problem is that you create an incentive for litigants to try to affect the path favorably, to have a substantial imprint in the direction of doctrine. Here comes standing. Standing says, in effect, that in order to get your case heard in a federal court, you have to be struck by a figurative bolt of lightning. You have to have an injury that was caused by somebody for which the judicial remedy creates meaningful redress. You can't raise the claims of third persons, and you can't raise diffuse harms. It is the functional equivalent of the lightning bolt hitting you. If you have been hit by that figurative bolt of lightning, you get to get your case litigated in federal court. Now, here's the thing. The figurative bolt of lightning method of path-induced decision-making doesn't make it less path-dependent, but it does make it less path manipulated. And so the argument is that standing has the effect of rendering the paths of developing doctrine more fair. Now that might sound theoretical, so let me give you an example. These are two Supreme Court cases that were decided on the very same day in 1982. The details aren't hugely significant. They happen to have to do with whether state jurisdictions that were not in violation of equal protection doctrine could use busing as a means of integrating public schools, even though there's no equal protection violation. One of the cases arises out of Seattle, California. Great. Here I am in Irvine, California. It arises out of Seattle, Washington. The other one arises through a California well, one's a Washington referendum. The other one is through a California amendment to the Constitution. Now, there's a minor distinction in the two cases, but it's minor, and it's debatable whether it matters. The critical point is the following. The California one gets upheld. The Washington one gets struck down. Let's look at the votes for a moment. The California one, which is Crawford, is 6 with 2 concurrences and 1 dissenter. The Seattle one, which is struck down, is 5 with 4 dissenters. Notice the asterisks next to the names of 5 of the justices. 4 in dissent in Seattle, 4 in Seattle matching up to the same 4 in the majority in Crawford. 1 in dissent in Crawford matching up to joining the majority in Seattle. Those 5 justices join or write opinions in which they basically say these two cases are indistinguishable. They basically say there's no difference between these cases, and they vote consistently with that. The cases come out the same day. They vote to treat them the same way. But because these cases come down the same day, there's no stare decisis effect of one to the other. But there is clearly a cycle. If the Crawford case came up first and the court upheld it, if these 5 justices voted sincerely, they would ask, does Crawford govern Seattle? And they would uphold it. If Seattle came up first and it gets struck down, these 5 justices 1 year later would say, does Seattle govern Crawford? Yes, it does, and they would strike it down, and you would get precisely opposite doctrine in both cases with nothing changing, except A followed by B versus B followed by A. The key point is you cannot have a majority that strikes this one down, a majority that sustains this one, and a majority that says treat them the same way and honor all 3 majorities. Why? Because it's a cycle embedded within the cases. Right? So it is in fact the case that the ordering of cases can have an impact on doctrine, and standing is not about preventing the ordering from having an impact. It's preventing the ordering from being, not preventing, that overstates it. It is about raising the cost of manipulating that kind of ordering. This is a slide about a debate that I'm in the middle of now with some people having to do with standing and the durability of precedent. I'll skip that because we're in California. You like this one better. So I became interested in plebiscites, and that's how I actually got to know Rick. And it's not really reasonable to do this fairly lengthy article on a single slide. So indulge me. I'll just try to get the general point across. There's a general sort of understanding that direct democracy is the most democratically legitimate system of governance because the people are making the choices. Okay. Well, I have to say I'm skeptical of those sorts of claims. And so I set about extending the analysis that I use to compare courts and legislatures to think systematically about direct democracy. And what I came to discover was somewhat striking. It turns out that the social choice profile of direct democracy is precisely that of appellate courts and precisely not that of legislatures, by which I mean that what direct democracy does is it sends something out for a binary vote to the electorate. It forces a resolution, except in the statistical improbability of a tie, which would never occur given large numbers. And it prevents the weighing of preferences, and it sets something out so that it will definitely be resolved. But legislative bodies don't work that way. Legislative bodies, this goes to the conversation Linda and I were just having, they don't have to resolve issues. They can decide not to resolve issues for any number of reasons, including but not limited to substantial opposition based on intensities of preference, which binary voting isn't going to account for in an electoral setting. Or they could decide that there's a cycle. Or they could decide we'd prefer to roll that in with many other issues and deal with it over a multidimensional context. But in fact, what direct democracy does is prevent that from occurring. It slices off a single dimension, sends it to the voters, forces it to a vote. What's really interesting about this, I think, is ideological conservatives tend to be distrustful of judicial review. Why? Because it isolates single issues, takes it away from legislative resolution, forces it to a decision. But they tend to really like direct democracy. Liberals tend to not so much like direct democracy, but they tend to really be big fans of judicial review. There's something curious about that. It's at least worth thinking about. It probably has something to do with the scored victories each side thinks it can obtain, but the structural mechanisms bear a striking and I think problematic similarity when we're thinking about democratic legitimacy, which brings me to the present day. So it's fair to say that the project in which I've been engaged for now 2 decades plus, if you think of constitutional law as subdivided curricular-wise into Con Law 1, structure and governance, Con Law 2, individual rights, and then you might have a tack-on course for First Amendment. Most of my writing has been Con Law 1, until one day I woke up and I realized, I think I have something to say about Con Law 2. That's this paper. So one of the most contested doctrines in constitutional law, right up there with standing, is a doctrine called tiers of scrutiny. Like standing, it's lawyer's law, but lawyer's law that non-lawyers really need to know about because of how much it matters. In effect, in cases that arise under equal protection or due process, the Supreme Court has a set of rules that it uses to decide how hard a time it's going to give to the lawmaker that passed the law. And the standard traditional scheme had 2 tiers, and then more recently we have 3 tiers, although one might argue we have 5 tiers. We'll get there in a moment. The most basic scheme is strict scrutiny or rational basis. Strict scrutiny is usually fatal to the challenged law. I will articulate the test on the next slide, but just take my word for it for a moment. Usually fatal to the challenged law, but we have recently been told strict in theory is not fatal in fact. The court said that in a 1995 case involving a general contracting rule favoring minorities. Trivial significance. What is significant is that it used that in the holding for the University of Michigan Law School's affirmative action case. It applied strict in theory in a way that was not fatal. And in fact, by sustaining that program, more recently in the Fisher v. Texas affirmative action case, Justice Kennedy remanded it and said, well, strict scrutiny might not be fatal, but nor should it be feeble. So we don't really know what that means anymore, and I'll talk more about that in a moment. Rational basis scrutiny is supposed to be fatal to the challenger, meaning it's supposed to let laws survive. And yet, there's a handful of cases in which the Supreme Court says that we're going to strike this down even under the lax test of rational basis scrutiny, and I'll talk a little bit about that as well. And then we have this curious category called intermediate scrutiny, which generally is applied in cases involving sex and equal protection, laws that draw distinctions based on gender that are challenged under equal protection. And what we're going to see is that although it sounds like intermediate scrutiny, it actually might be the case that it, in application, looks more like either strict or rational basis scrutiny. So in the paper that I sent to you all, I didn't include these 2 tables, much to my regret, but I will include them before this thing gets published. And it's simply to say the following. If you look at the black letter law on tiers of scrutiny, you might think the world looks like this. We have rational basis scrutiny, which is really, really lax. Sometimes they use rational basis in a less lax way. We call that rational basis with bite. Then we have intermediate scrutiny. On the opposite end, we have strict scrutiny, but sometimes they don't do it in a very strict way, so we'll call it strict scrutiny light. So now we have 1, 2, 3, 4, 5, except not quite, because when the court uses strict scrutiny light, it sustains the law. When the court uses rational basis heavy, it strikes the law. So what we really have is 1, 4, 3, 2, 5. And I think it's fair to say that nobody would think that makes sense, intuitively. That the way we should structure our tiers is rational basis, strict scrutiny, light, intermediate, rational basis with bite, strict. That just doesn't make sense. This paper tries to explain what's going on. That's the purpose of this paper. And what I argue is that what's going on is a social choice dynamic. This is a doctrine that fails to recognize an underlying problem of dimensionality. And I hope to persuade you that I am right. So now let me give you a little bit of black letter law. This is Con Law 101 for economists and mathematicians. So here's what happens. We have black letter rules for strict scrutiny and rational basis scrutiny. Keep the other standards aside. The black letter rule, right out of the case book, right out of the cases, is as follows. Strict scrutiny demands that the government prove two things. Number one, that it has a compelling interest in support of its law, and that the means are narrowly tailored to the particular interest that it has. Now, the government has to prove both of those things. If a law is challenged under strict scrutiny, say a law that discriminates on the basis of race, the government would have to prove that it has a compelling justification for doing that and that the means are narrowly tailored. There isn't a non-discriminatory way to accomplish its goals. Even then it would get struck down, probably. Rational basis scrutiny flips it around. Rational basis scrutiny covers the gamut of most ordinary regulation, economic regulation, general regulation, police powers regulation, and it leaves the burden of proof on the challenger to demonstrate the absence of a legitimate governmental purpose and that the means are not rationally in furtherance of whatever that purpose happens to be. Whereas strict scrutiny is a conjunctive test, the government has to prove A plus B to win. Rational basis is a disjunctive test. The challenger must prove A or B to win. Okay. Now, the way to understand all of this, I think, isn't very hard. Imagine, contrary to my actual life, that I have a desk that is clean. And on top of that desk, I have two bins. One bin says presumptively good laws, the other bin says presumptively bad laws. And here's what happens. The cases come in on the Supreme Court. Okay? If I have a case that draws a distinction based on race, goes into the bin, presumptively bad laws. If I have a case that impinges upon a fundamental right, it prevents women, for example, from terminating unwanted pregnancies, at least in early stages of the pregnancy, goes into the bin for presumptively bad laws. Denies access to contraceptive, goes into the bin for presumptively bad laws. Minimum wage law, ordinary economic regulation, goes into the bin for presumptively good laws. Okay. Now, what the tiers of scrutiny does is two things. One, it does this stage one initial sorting. It tells you which bin to put the cases into. But then it does something else. It also tells you that there are exceptions where you may not get it right with your initial sorting. And what these instructions, strict scrutiny requires a compelling governmental interest in means that are narrowly tailored, means go through that strict scrutiny bin and see if there's something that shouldn't be there. Similarly, on rational basis, absence of a legitimate governmental interest or reasonable connection, go through, see if there's something that doesn't belong there. So you might ask the question, well, why go through this exercise of a two-stage process when you've already told us what it is that puts them in their respective bins? And the answer takes us back to another interesting social choice theorist who wasn't writing about social choice when he made the observation, Lewis Carroll, who was a mathematician. And this is a scene from Alice in Wonderland, or Alice looking through a looking glass, and what Alice found there. And the scene is this. Alice is running with the Red Queen. And they're running, and they're going faster and faster, but no matter how fast they go, they are in the exact same place. And Alice says to the Red Queen, well, in our country, you generally get to somewhere if you run very fast for a long time, as we've been doing. And the Red Queen says to Alice, a slow sort of country. Now here you see it takes all the running you can do just to stay in the same place. If you want to get somewhere, you actually have to run at least twice as far as that. And what I argue is that constitutional law is a Red Queen game, by which I mean the following. Here's what happens. Go back to the desk with the bins. the legislature knows about the bins. They're aware of your bins. And so they know that if they want to accomplish a particular objective and they draw the line based on race, it goes into the strict scrutiny pile, done. They're not going to win. So what do? Well, they try to craft a way to get that done in a way that puts them in the bin they want to be in, which is the presumptively good bin. So they come up with a gerrymander, which is articulated in a race-neutral way, but has the purpose and effect of doing the same thing that they are not permitted to do in blunter fashion. And so what happens is we have these instructions that say, you're looking for that case. And by the way, over time what will happen is that purpose and effects test will then be categorically classified into the presumptively bad bin, but this continues on and on, right? This goes back to the conversation, Chris, about what is law. It depends what you mean by that, because law might be a never-ending process in response to a Red Queen game. It might not be Moses carrying the tablets down from Sinai. It might be the interpretation of those tablets or whatever the initial source of law happened to be. Okay, now, the question is how dimensionality relates to all of this. And it does profoundly relate to all of this. This is going to be very simple for the mathematicians and the economists in the room, but it is helpful, hopefully, to the lawyers, not these law professors. You all are going to understand this intuitively. But let me just take you through the steps. The point is that a single dimension is adequate to the task of sorting an infinite number of data points. So, for example, you can divide numbers, integers, into odds and evens and continue the sequence forever, right? It goes on indefinitely. Okay. Similarly, primes and non-primes are sufficient to sort an infinite number of data points. You can keep running primes and non-primes forever. So you can have an infinite number of data points along either of those alternative dimensions. But what if you have a small subset, a simple mathematical sequence, 2, 3, 4, the bolded numbers, but you want to sort them according to whether they're odd, even, prime, or non-prime? Can you do it on a single dimension? And the answer is no. And the reason is because the primes are all odds. The 1 should be knocked out because that is a, forgot to erase my 1. Sorry, Don. Forget the 1. It's a number that can only be divided by itself, and 1 yielding a whole number or an integer, except for 1, a number greater than 1. So I should have left that out. Anyway. The problem is that 2 is an even prime. And so as a result, there's no way to account for both the prime dimension and the odd-even dimension in one dimension. I give an example at the beginning of the paper of hot air balloons, right? You might think as objects become bigger, they become heavier. Well, what about the hot air balloon? It's really big, but it floats, okay, into the air, right? 2 is the hot air balloon of integers, in effect. Okay. The other thing that I need to persuade my not these law professor colleagues, but law professor colleagues is the following. Along a single dimension, you can have a changing line without sacrificing the dimension. So, for example, here, the age of maturity from childhood to adulthood has historically changed over the millennia, right? If you go back to the early ancient Jewish tradition, the bar mitzvah 13 becomes an adult. Nobody believes that. Right? None of my Orthodox friends will tell you that their 13-year-old son is an adult. Okay. What about high school? Well, do they really believe that? Not so much. What about graduating college? Maybe, but I've got one who's a sophomore. I don't see it quite. And let me say she's a terrific, responsible child. But an adult? We'll see. And Obamacare tells us it's 26. Okay. Right? Obamacare tells us the new adult, right? The new adult, the new 13-year-old happens to be twice that old. In fact, I will say this. When I started this project, I was thinking, this is good because with one more doubling, I've still got time for youthful indiscretion, but I already turned 53. It's over. Okay, so the point is that you can move the line without affecting the dimensionality. This is the slide that's the key to the whole project. This is the key to the kingdom. It's not the only slide left, but it's the key to the kingdom. The argument that I make is what the Supreme Court ultimately has confused in its tiers of scrutiny is failing to recognize the underlying dimensionality of its constitutional case law. And it's done it in 2 ways. Number 1, it has failed to recognize that in a very specific race context, it has a multidimensional problem, and the two-tier system therefore doesn't work. And that in another context, sex, it thinks it has a two-dimensional problem, but it actually doesn't. It has a one-dimension problem, and therefore the two-tier system would work. Now, why is that? The reason is that affirmative action is the number 2 or the hot air balloon of constitutional law. Here's why. The way to think of this is that there are 2 issues at play that relate to our race jurisprudence historically. One is, do we condone or not condone the adverse use of race? Throughout our era of Jim Crow, up to Plessy, up to Brown, that was the debate. Does a law that treats blacks poorly survive equal protection analysis? In our more modern era, we've introduced another dimension of choice. Do we condone or not condone the benign use of race? Now, what that means is that we have 3 categories of folks who sort of represent different strands of jurisprudence. We have the modern liberals who will condone the benign use of race but not the adverse use of race. The old Jim Crow position was the opposite. They would condone the adverse use of race, but they didn't think it was necessary, or they wouldn't condone the benign use of race. We have this position, the colorblind position, which would not condone either the adverse or benign use of race, any use of race at all. And you might think that because the modern liberals and Jim Crows are so far apart, that it must be the case that the colorblind position stands between them as a Condorcet winner, but you'd be wrong. And the reason you'd be wrong is because it turns out the modern liberals and the Jim Crows actually have something in common, diametrically opposed to the colorblind view, which is they'll both allow the use of race for something. Okay? Now, we'll come back to that. Let's talk about multi-criterial decision-making, thanks to Leo, who got me thinking about this. And this is, again, the standard cycling preferences, and Leo tells us that cycling can result from either the combined member preferences, but it can also result from rules. Rules that force consideration, perhaps of positions that were occupied in the past but are no longer occupied, but they're codified somehow in a rule. So here's the idea. We have 3 people with cycling preferences, ABC, BCA, CAB. Okay. Imagine that P3 with CAB retires. But it's not the case that P3 has lost interest in what she's done for her whole career. She's just retiring. So she gets P1 and P2 to agree to a rule. And the rule is you have to pretend that I'm in the room no matter what you do. Okay? You have to treat my preference as if they're still present. It's a rule that constrains your choice set. And so what happens is we replace P3, the human being, with P3, the P3 rule, which means we have the same cycle with or without P3 in the room. Okay? Now, Don tells us that cycling arises from the curse of dimensionality. That, by the way, was the quote that Bernie Groffman told me that I should get in touch with you over. But here's the interesting thing. Of course, you're absolutely right that cycling arises from the curse of dimensionality, but from the standpoint of P3, the cycle's a blessing, not a curse. If the thing she fears the most is an adverse outcome that a cycling which leads to inertia will prevent, well, then cycling results from the blessing of dimensionality. And her rule, by forcing multi-criterial decision-making, has actually forced dimensionality. And, okay, do I want to go there yet? Yeah, so if you go here to the slide that I just talked about, here's the intuition. Nobody occupies Jim Crow today, obviously. But notice the different lessons from that position that these 2 groups have drawn. The modern liberal position is don't subordinate based on race. Cite Jim Crow. The colorblind say don't discriminate based on race. Cite Jim Crow. And in fact, I'd like to just focus on some language from a couple of Supreme Court cases. So we have the famous Plessy versus Ferguson Harlan dissent that first articulates the colorblind Constitution. And here's what he says. He says, in view of the Constitution, and you all know Plessy v. Ferguson, it's the law that is associated with a separate but equal doctrine. It sustained a segregated railway car regime against an equal protection challenge. Okay? It's one of the low points in our constitutional jurisprudence. So what Justice Harlan says in dissent is, in view of the Constitution in the eyes of the law, There is in this country no superior dominant ruling class of citizens. There's no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens in respect of civil rights. All citizens are equal before the law. So I tell my students, yeah, the colorblind metaphor is completely wrong. If you're colorblind, it emphasizes black and white, okay? Gets it completely wrong. But nonetheless, we get his point, which is not that you're colorblind, but that you don't take them into account legally, black or white. Fair enough. And Justice Thomas, concurring in a case called Parents Involved, a case that prevents, that strikes down a regime of race-conscious measures that are designed to maintain the integration of public schools against demographic reversion to single-race schools. He says that the dissent's criticism can be traced to its rejection of the colorblind Constitution. The dissent attempts to marginalize the notion of a colorblind Constitution by consigning it to me and members of today's plurality. But I am quite comfortable with the company I keep. My view of the Constitution is Justice Harlan's view in Plessy. Our Constitution is colorblind, and you can read the rest of it. And it was the rallying cry for lawyers who litigated Brown, which is actually historically questionable proposition. He even made a stronger claim a few years earlier where he said that there's a profound moral and constitutional equivalence between laws designed to subjugate a race and laws that distribute benefits on the basis of race to foster a current notion of equality. This is essentially the slide we just had as applied to the particular case. Dissent position, in this case is the modern liberal position. This is the colorblind position, and this represents the Jim Crow position. Okay. And so what we have here, in effect, is Justice Thomas making the claim that these two positions are morally equivalent. And the question is that true? Because the colorblind Constitution is debated in a context in which the choice is either to have race-specific laws that invariably create a white racial caste system to the detriment of blacks, and so therefore colorblindness is the liberal position. If the only regime you can anticipate that's race-conscious creates a racial caste, then the colorblind position is a liberal position. That's what it's responding to. But is it fair to say that the liberals, who would allow the use of race for benign but not for illicit purposes, are morally equivalent to Jim Crow? Yes, they'll allow the use of race, but what they're saying is that the lesson of Jim Crow isn't colorblindness. The lesson of Jim Crow is not subjugating or subordinating based on race. And this is why you ultimately have a problem of dimensionality in the race jurisprudence. If you're going to have a category in which you permit the benign use of race, and you say you're going to apply strict scrutiny, you're inevitably going to end up torturing the strict scrutiny standard. It can't be applied in a sincere way. For a period of time, the court applied intermediate scrutiny, treating it as a different analytical category that is motivated by two separate principles of equal protection. One is a discrimination principle, racial discrimination permitted or not. The other one is a subordination principle, right? Is racial subordination permitted or not? You need to take both dimensions into account in your tiers of scrutiny analysis. But when you insist that all of these have to collapse, then the only way you can sustain a law that's race-specific is to apply it in a disingenuous way. This last case on race, before I turn to sex, is Loving versus Virginia. This is a Virginia anti-miscegenation statute. It works like this. Interracial marriage is prohibited, but does it discriminate on the basis of race? Might seem like it does, but here's the problem. For every minority that's subject to the anti-miscegenation statute, so too is the white person who married him or her. So it isn't discriminatory, but it's clearly subordinating. And so here's a striking result. The conservatives and liberals agree on prohibiting subordination and reject the Jim Crow position, which would allow subordination. So there's a case where the dimensionality collapses because there's no discrimination. Let's talk about sex. That was a song. Anybody know that? Okay. It works with my students, okay? Anyways, different crowds. You have to feel the crowd, right? Okay, so here's the question. Does the same analysis work for sex? You could imagine the following. This is the third table, the one that I told you was the key to the whole thing, applied to sex. So do we condone adverse sex classifications or not? Do we condone benign sex classifications or not? The modern liberal position would condone benign but not adverse. The kind of old fogey position would condone adverse but not benign. And then, who are these people? Are there people who actually take a sex-blind view? Well, there is a school in Sweden where they do that. No joke. There is a school in Sweden where, and it's voluntary, the parents choose to send their kids there, where they eschew gender-specific pronouns. Everybody is a friend. Don't know how they deal with the bathrooms there. I'm just not sure. But they do. They eschew any reference to sex whatsoever in that context. But we don't have it in our jurisprudential tradition. I should say in the bathroom, it's a really interesting question. One of my colleagues is actually doing litigation on that very issue in Maryland, right? So it's really for transgender, right? So there's really interesting issues there. That, too, is going to be similar to the analysis that I'm engaging in here. The point is, because there isn't a normative commitment to sex blind the way there is to race blind, the dimensionality ultimately collapses. And what we really have is a single dimension of subordination, right? It's not about the discrimination in the context of sex. Liberals and conservatives agree about the permissibility of using sex. They just disagree about where the line should be drawn. And generally speaking, if you read the cases, what you discover is this. If the case remedies the present effects of past discrimination, or if it accounts for real sex differences, it gets sustained. If it's based on traditional gender roles, it gets struck down. There are some hard line drawing cases, but at the end of the day, this is basically rational basis. This is essentially strict scrutiny. Intermediate scrutiny is doing nothing but adding confusion on final exams, which helps me to grade, but it doesn't provide a societally beneficial function. Same-sex marriage, I'll just close with this, I think. Yes. Same-sex marriage, this is the hot civil rights issue of our time, and I offer some speculation in the paper as to what the court might do. It could apply intermediate scrutiny, but of course that only asks which version, the light or the heavy version. It could use rational basis the way it has used the animus version of rational basis, which is with teeth, which itself is a kind of disingenuous move. Or it could apply strict scrutiny. But the court doesn't seem inclined to do that in the context of same-sex relationship issues yet. That might be, in fact, one of the reasons why the court dealt only with Windsor on the merits and deferred on Hollingsworth. Unclear. But in any event, those are the options, assuming the court's going to strike down prohibitions on same-sex marriage. I'm pretty confident that it will, for reasons I can explain. This is some of the sources, and that's it.
Questions? Whoa, wow.
Yeah. Quite a tour de force. It really shows the contributions you made to the field. Well, thank you.
Benefit a lot from reading your work. I haven't read this yet, so I appreciate the presentation. When I first heard it, I thought it was scrutinizing tears, T-E-A-R-S.
That's as bad as a sex joke.
Justice Scalia gave an interview to the New Yorker recently where he said, strict scrutiny, blah, blah, blah. So my question is, why are you taking doctrine seriously? He's talked about stare decisis, respect for precedent. He talked about standing, and he talked about levels of scrutiny. I think of all three of those areas as places where the doctrine is completely manipulable, where the judges or justices' policy preferences often trump consistency with past precedents. And so another way of explaining strict scrutiny light and rational basis fight is they're just coming up with fancy names to mask their pushing their preferences through. And I'm wondering if we take doctrine less seriously, what are the implications for your model? And maybe it's not that it's, maybe we shouldn't be caught up with the labels they're putting on. What we really care about are the vote outcomes. The conservatives are voting in a particularly consistent way, and the liberals are voting in a particularly consistent way, and what they call it doesn't matter.
Yeah, no, that's a great question, and a fair question. My general answer is, I confess I tend to take persistent doctrine seriously, in the sense that we've had this schema for a long time. It's been manipulated, but it hasn't been abandoned. And there is a kind of path dependence inherent in this. The fact that the court uses strict scrutiny, for example, in the race context, does create some actual application problems, maybe not in the Supreme Court's own precedents, because it can manipulate, but in lower courts' application in ways that a more straightforward application of the doctrine might not. But I also think, frankly, that it is cleaner to acknowledge the dimensionality, because it would allow you to basically make sense of this. You could have rational basis where it belongs. You could have strict scrutiny when you've actually got a fundamental right being challenged or a suspect classification, and you'd have this isolated third category of benign race preferences. And it would be clean. And you'd do away with a bunch of anomalies, one of which is the historical anomaly that the 14th Amendment was adopted to benefit freed slaves. And yet, because of the peculiarities of the tiers of scrutiny, under the 14th Amendment, states can enact an affirmative action measure for women who are actually discriminated against in the express wording of the 14th Amendment, but not for African Americans. Why? Because women are subject to intermediate scrutiny, but African Americans to strict scrutiny. So recognizing the dimensionality problem would solve some concrete puzzles that matter, and I think it would legitimate. In other words, if you're right that this is sort of subterfugal preference voting, well, channeling the doctrines in a way that makes more candid what the stakes are in cases, I think is beneficial. It's an interesting thing, because I had a lot of the same kind of comments on standing, where people said, well, it's all manipulable. Why are you focusing on this? Well, part of it is, it's like Tony Soprano when he went against his best friend. He said, why do you do this to me? He said, well, that's what I do, right? I mean, part of it is because it's what I do. And I like to not think of myself as Tony Soprano, but it is what I do, so I obsess about the things I obsess about. But I actually think that bringing doctrinal clarity or analytical clarity to an area that's confused is salient and has potential payoffs. And so, yeah, it's what I do. Okay. Do you want to do the cue? You want me to?
Well, go ahead.
Yeah, this is great. And obviously, I didn't read it on time by yesterday.
That's okay.
So I want to complain about standing.
Okay.
It seems to me that it's manipulable in a particular way, which is to say that it's one-sided. So I know that state attorneys general don't have to defend cases if they don't want to. I mean, they can be dragged kicking and screaming to the courtroom, and it doesn't do very much good if they decide that
Right.
they're not going to go up against the court's decision on gay marriage. They just won't.
Right.
But one sees this much more generally that whoever the appeal can be brought by the person who's lost a case. They don't have to. So on the one hand, you have to have this what do you call it? Bolt of lightning to get into court.
Right.
But you don't need to have bolt of lightning. You can have a bolt of lightning and not bother going.
Okay, now that's a fair point. And I actually did write about the Hollingsworth issue that you're implicitly referring to. So let me just explain it for those of you who don't, who don't sort of, you're not in the inside baseball of Supreme Court decision-making on standing, which is shocking for me to acknowledge that there are people like that. But what happened was, the Hollingsworth case arose, of course, from the California, was it Prop 108? Prop 8, I'm sorry, Prop 8, that prohibited same-sex marriage, basically overturned a California Supreme Court case that recognized same-sex marriage by prohibiting same-sex marriage. And of course, the state attorney general wasn't willing to defend the law. The governor wasn't willing to have the law defended. And so what happened was the defense of the law, and I think this was actually approved by the state legislature, was the folks who actually got this balloted. And so the question was whether they had standing or not. My own opinion on that, just so you know, for whatever it's worth, so I don't count, I'm not one of the votes that count. My own opinion on that was that was actually not a terribly difficult question, and the court got it wrong. And it's sort of interesting, by the way.
You have another shot at it.
Yeah, well, no, that's right. But it's interesting. I was at a standing conference with Judge Fletcher of the Ninth Circuit, who's, I believe, is he retiring? Is Judge Willie Fletcher retiring?
He's up for the deanship at Berkeley.
Oh, is he? Oh, very interesting. He's a wonderfully nice man, I have to say. But it so happens that there were 9 people at this conference focusing on standing. And so I sent off to the other court, their opinions on the standing votes in Windsor and Hollingsworth, and the weight of authority was opposite the Supreme Court that decided the two cases. So my take on Hollingsworth is as follows, that I am not a fan of initiatives. I think I've made that clear. But if you're going to have them, I think that those who create the law should have the opportunity to defend that law, because otherwise you're not acknowledging a legitimate lawmaking process in the state jurisdiction. So I think substantively the standing decision was wrong, and I would have dissented from it. And I wouldn't have been crazy to do that because I think it was 5-4 or 6-3 on that standing issue.
On the other hand, keeping it out of court might have maintained your underlying.
Well, so there's the other part of my thesis was, but the reason why I think it happened was that I'm pretty sure Kennedy would have voted to actually strike it down, and he would have come up with some test to do that. I don't think that he that he would have been suddenly pulling back from what is part of his legacy on issues relating to gays and lesbians. I just don't believe that. It doesn't make any sense. But I do think that some of those who joined that dissent probably thought that there'll be more legitimacy if there's another, time goes by, more cases than just suddenly having it resolved so quickly, which goes to your point. It's a one-sided rule, sort of. I think it's a little overstated, but I think you're close to right. And it does relate to docket control. So here's the intuition. So again, inside baseball, the way the Supreme Court chooses its docket it wasn't always like that. There used to be two aspects of jurisdiction, one which was mandatory, one of which was certiorari, which is sort of controlling its own docket through the rule of four, where 4 justices vote to take a case for which a petition has been filed, then they take the case. Okay. Now, what I've argued is that you actually need the combination of the cert rule and standing to limit agenda manipulation. The reason... Just finish the thought. The reason for that is exactly what you were alluding to before, Linda, which is this, that a way to force the court to take a case, or at least make it much more costly for the court not to take a case, is to force a circuit split, right? Or either a circuit split or a split among highest courts of jurisdiction across the states. And so what you really need to do is to have both of these tools in place, not just one. And so you're right about the one-sidedness of it, but it's not a perfect rule, but it certainly raises the cost in a meaningful way of path manipulation, which is the point that I'm trying to make, and fulfills the function. Well, because of this case. But the odd thing about that is...
The federal government, when they appeal, they tend to...
Oh, clearly right. Yeah, the federal government...
So if they decide...
Yeah, the federal government does have a kind of prioritizing right that private litigants do not, and yes, and that's undeniable. Yeah, I agree with that. Yeah.
Bruce?
Yeah, so just help me out a little bit about the following. Normally when you think of adding dimensionality and you sort of allow or you permit moves in these additional dimensions, which is, in some sense it seems to me these additional tests are allowing, you think of yourself as destabilizing, right? The possibilities of choices. That is to say, now there's the possibility of moving, in the northeast direction as well as the north and east.
Right.
You can do some combination of these ideas. And so when we look at these results, like McKelvey or something, right? We think of that as problematic
Right.
for stability, or problematic for avoiding cycling path dependence, right? So I'm trying to figure out where this strategy later in the paper you have of accommodating multidimensionality fits with your concerns earlier in your presentational piece,
About cycle breaking rules.
where you're worried about
Right.
path dependence and manipulation and so on. Right?
Yeah, no, it's a good question. So let me explain. My general approach is a positive approach, trying to explain the rules as they exist. And that really is the early part of my presentation of what I've been doing for the last couple of decades. This is a bit of a more normative project, because what I'm saying is that although I'm accepting the general framing, I think the court's kind of botched it in the application. So I am being more normative, but I do think it's actually cycle minimizing, because the category of cases in which there's a dimensionality problem is extraordinarily isolated. In fact, what the court has done by introducing intermediate scrutiny where it doesn't belong is suggest dimensionality in gender cases where there is none. But in the context of race, there typically isn't going to be dimensionality either because the anti-subordination dimension captures most of the cases. It's only in that rare instance in which you've got a discrimination and anti-subordination principle combined, and it only comes up in racial preference cases. So what I'm basically doing is saying, yes, we have dimensionality, but it's in this really specific and confined area. So I think that, in fact, the analysis would have an effect of stabilizing rather than destabilizing because of the limited set of circumstances to which that rule would apply. So I don't know if that quite answers your question, but that's my reaction. Yeah.
This again is fascinating, and again, the reason for my first question was precisely this point about, deconstruction, reconstruction, and the change in law and the cycling. The two issues come together. The notion that corporations are treated as people
Right.
is, as you say, a mistake, as I might say, a manipulation.
Right.
We can't say that those occur in isolation.
Right.
Because we are always trying to game the system. I mean, it is simply the fact that lawyers and the contention between them is a game of competition. So if we take that into account, we understand the world is behavioral. This point was made here, and I enjoyed Linda's point. You really come back to personal preference. And this is the subject of this conference, social choice and the law. If you deny that there's this behavioral component, you referred to Kahneman and Tversky and the work they did, and this sort of this tinge of irrationality we go through, you risk over-intellectualizing, and you said this is what you do. I enjoy so much the law because of the intellectual chase you have. But it reminds me of when I studied, as a PhD student, Friedman economics in 1975. I stood up in my orals and I fought brutally for Friedman, and I got points for doing it. But the sort of rule of life says it's not like that, and the rise of behavioral economics resulted. If you fight the behavioral component by saying, I'm going to just make these procedures more and more and more complex,
Right.
you're behaving much like classical economics with adding these tiers upon tiers upon tiers of mathematical manipulation to make some sort of regression come out. It seems to me if you're sort of like Justice Scalia and say, I want to interpret the Constitution word by word, you're denying that people are behavioral, that sort of meanings change over time, that there's a relativism that changes Jim Crow laws into civil rights laws over time following the zeitgeist. And we have, because of this mistake of the Southern Pacific Railway, or the manipulation that results, not an isolated case, but an insecurity in the law that makes it subject to that sort of manipulation, and this incredible perpetuation of a bad precedent. So we have then some sort of need to come back, rather than intellectualizing a justification after the fact, much as classical economics is trying to do, some sort of revision of thought that allows for logic. Not just strictly driven by the precedent, but let's come back to what society really says now. I find it very hard for those people that interpret the Constitution literally to say, wait a minute, gun laws didn't anticipate AK-47s, all that sort of stuff. But we have people that say, wait, it doesn't matter, it doesn't matter. Well, it does. So if we talk about societal preference, which matures, we'd like to think, but certainly changes over time, how do you allow for this sort of behavioral issue, this important change reflected by society, rather than just precedent by precedent dimensionalization? This goes back to the tyranny of dimensionalization, which can take you way off track and keep you there.
There's a lot there. And I'm going to try.
Your quick answer.
And I'm going to try to answer. And I'm going to try to answer some of it. And I have no doubt that I will not do what the justices deserves, which is simply to say, I hope you'll follow up with me for the 90% that I'm likely not to get to. But let me just pick up on a few of the salient points. First off, I don't think you meant to imply that I'm being Scalia-esque, because actually
No,
quite the
that's
contrary.
an extreme
I don't mean it in an ideological sense, I mean in a literal doctrinal sense. Actually, his position is precisely the position against which I'm advocating here, substantively, because he's in the Thomas colorblind camp, so it's actually the opposite. But I didn't understand that to be your point. What I did understand you to say is that this over-intellectualization has a risk of adding layers of complexity that could exacerbate manipulability. Is that roughly what you're saying?
Very much.
Okay, so let me offer a couple of reflections on that. Let me come back to the very first thing I said, where I said the gentle madness doesn't go away. It manifests itself differently, and it reflects something about social choice, where the problems don't go away, they manifest themselves differently. I think I need to come back to that point to answer your question, because, in fact, I believe that doctrine operates as a kind of constraint, not an absolute constraint, but a kind of constraint. And the thing that law professors push back with me to prove the opposite, I believe, strengthens my case, not theirs. And it goes like this. The Supreme Court manipulates doctrine to get to places it wants to go. Does that prove doctrine's not a constraint? No. It proves that the path dependence manifests itself in doctrinal moves. But those doctrinal moves then create their own constraints. It makes it harder to get to where you want to go. If you're subject to doctrine that you've created to avoid this problem, it can come back to bite you when you have a different problem. And so, in fact, I don't think that doctrine is eminently manipulable. And I do think that judges and justices in particular spend a lot of time thinking about the price and trade-offs associated with doctrinal manipulation. In other words, I think one of the things that they do is they say, okay, if to get there we have to do this, are the consequences of the this worth the benefit of getting there? And that is about path dependence embedded in doctrine rather than in a formal cycle with respect to outcomes. And I teach constitutional law, so I can only say I see it all the time. So rather than suggesting that it's all about preference vindication, and so none of this matters, I would say quite the opposite. To the extent it's about preference manipulation subject to doctrinal constraint, all of this matters because the social choice problem is not going away. You have to really dig in and know how to find it, going like the Riker point, except in this context we're talking about judicial decision making, but it's there if you're looking. So I don't think that quite answers all of your question. The only other thing I'll say is the answer I gave to Bruce on whether adding layers of analysis exacerbates opportunity for manipulation. I actually believe that this analysis is not adding complexity. I think it's actually adding simplicity. I'm saying there's one tiny category of case that has a dimensionality problem and the rest of it's flat. Here's what I really expected to hear from you social choice folks. Stearns, really? You're really telling me that there's no dimensionality in Supreme Court cases except in affirmative action cases? That was the question I was expecting to get, but I'm getting the opposite question. Well, now you can't ask me that question. It's off limits now. No, I'm kidding.
We'll do that at a break. I'm going to ask Charlie to make a comment. I'm going to ask you a comment in terms of from social choice. I'm going to ask Leo and Charlie, then we're going to have a break, and then we can. We're going to ask him to break then. Okay. Leo?
Yeah, Max. I'm just now narrowly going to focus on this, on the particular problem here about tiers and dimensionality. So I take it the strange thing that's going on and that attracted your attention is that so the Supreme Court divides these cases into these two bins: the strict scrutiny, the rational, the much more lenient, rational basis test. Then there's a subcategory of cases in each bin where in one case where it seems to apply the approaches in a seemingly disingenuous way. In the strict scrutiny case, applying the strict scrutiny approach in such a lenient way so as to get an approach, an outcome that allows them to approve what's being done, and then similarly the rational basis test suddenly in such a strict way as to get the opposite result. That's where they look to be dishonest, and what you're saying is that they're, if one just takes account of a missing dimension here, they can avoid that. There clearly is something going on there, they do appear disingenuous. I'm with you in thinking that that disingenuousness may simply reveal that they sort of haven't translated into the appropriate doctrines decision, perfectly principled conclusions that they're reaching. I wonder whether the following analogy is helpful, whether the following captures what's going on, and whether that suggests that something other than dimensionality may be what's involved. So take another place where we sort things into two bins. In a civil case in which we first decide the question of liability and then the question of damages. Or in a criminal case, we decide the question of liability and then the question of the sentence. And then we often run into a situation where the plaintiff, the prosecution, has sort of weakly just barely managed to make the case for liability. Then we assess damages or we assess the sentence, and we are strongly tempted, if the case is weak, strong enough to establish liability, but not the strongest case imaginable in liability, we'd like to adjust for that in the realm of the sentence or in the realm of damages and reduce them. And often we'll engage in
even though technically we're not supposed to.
Disingenuous maneuvering in order to make up for the fact that we recognize liability, though it's not as strong a case as many others. Now here what's just going on is that there's a trade-off that's been forbidden and that we're trying by the back door to introduce. Does it describe things correctly to say that it's a dimensionality problem? I mean, it's not, for me, the most natural way to think of it. I just focus on the fact that there's this forbidden trade-off, and we try to get around it or reintroduce it by the back door in a variety of different ways.
You know, it's really interesting. Let me just say, first of all, the analogy I don't think it exactly works for me, because I think that the bifurcated trial case is more like the two stages within a pin than two separate cases across two bins. So I'm not sure it quite lines up in the same way. But it's interesting that Cooter and Peratt did work on this precise question. And I'm not expert in it, and it's not something I've spent a lot of time focusing on, but they talk about that. There are these cases where you've got this bifurcation, liability and damages, and where one is strong, the other is weak, or the reverse, and you may have, in effect, a compromise that is inconsistent with the understanding, and I do think it's dimensionality, that you're supposed to take each separate question along its isolated dimension. And in a way, it's almost like an independence violation, right? In other words, should you let your resolution of liability be affected by what you think you're then going to do on damages? Right? Should you, let's assume, for example, take a stark example from criminal law. Take a prosecutor who elects to prosecute somebody on a binary extreme charge when the prosecutor probably in her heart of hearts thinks that an intermediate charge is appropriate, but forces the jury to a binary choice of extreme or acquittal. Okay? I think you could either phrase it as an independence problem or a dimensionality problem if the jury says, we think this person is guilty beyond a reasonable doubt, but we know that the consequence of guilty for that is going to be 20 years, and we're not comfortable with more than 5, not guilty, right? I think there are lots of games like that. I confess I haven't written about them, so I don't want to kind of off the cuff offer speculation about them, but my own intuition is that there are different ways you could frame it. Game theory might be helpful, dimensionality might be helpful, but I have to think about it more. Independence might be helpful. I think there's a lot of interesting stuff there, but I also know it's not a blank slate. There has been some interesting work. Cooter and Peratt, I know, have done some work in theoretical inquiries in law. They did a specific article related to the liability damages question. So I don't know. I know it's not a very satisfying answer, but it's an interesting question. And I'm actually really interested in it because I'm going to be doing a law and economics book with my co-author from the public choice book. So I'm interested. I will be thinking about this question. Actually, that's going to be helpful in thinking that forward.
Instead of asking for Charlie to make a comment, I'll let you make your comment as you begin your talk in 15 minutes, and so we can take our break. And but before we do that, I want to say that the Board of Count was created exactly for this problem of extreme punishment.
Oh, really?
Small punishment. And I'll talk to you about that later.
Oh, really?
Back around the time, about 2,000 years ago.
Or at least in the 1770s, right?
No, that was...
Oh, he was writing retro.
Oh,
he was writing about
It
historical.
was way back.
Yeah.
So, second thing he mentioned about papers, and we sent them out to the different groups, but what we're going to do is I'm going to have them placed on the website. If that's okay with all of you, put them on the website, you know, the papers right by your name. So if you have any extra papers that you want to put inside there, we can, and if you have some that you want to add to the list, we'll put them on the website, and Linda, and what we'll do is so people can download them. With that, I want to thank you again,
Oh,
and let's
thank
have
you.
our coffee.
Thank you.